5 seconds to go. Start. This court may prospectively declare a law for posterity, notwithstanding the fact that no substantive relief could be granted in the said case for the reason that following the presidential proclamation, fresh elections had been held and new houses had been constituted. This court went on to declare the law for posterity as to the federal character of the Constitution, the nature of the power conferred on the President under Article 356 of the Constitution, and the manner in which such power is to be exercised for imposing President's rule in a state by dissolution of the Legislative Assembly. In Golaknath vs. State of Punjab 1967 2 SCR 762, this court declared that it is open to the court to find and declare the law but restrict the operation of such law to the future. Further, the observations made by this court in Odisha Cement Limited vs. State of Odisha 1991 Supplementary 1 SCC 430, while determining what relief that could be granted following a declaration of a provision of an enactment as invalid, are also relevant. This court held the declaration of invalidity of a provision and determination of the relief to be granted as a consequence of such invalidity are two distinct things. That in respect of the relief to be granted as a consequence of declaration of invalidity, the court has discretion which could be exercised to grant, mold or restrict the relief. In the instant case, the elementary question that requires determination is whether the challenge to the validity of the central government's decision dated 8th November 2016 to demonetize all rupees 500 and rupees 1000 bank notes having been adjudicated upon at this juncture, that is, after a lapse of over 6 years since the impugned action was carried out, the nature of relief that could be granted by this court at this juncture is to be considered. Stated very patently, the controversy in the present cases relates to the true meaning and interpretation of subsection 2 of section 26 of the Act. Therefore, the question that arises for consideration is whether this court can declare the law as to the validity of an action even after such action has been given effect to in toto. That is to say, once the action has been completely carried out and there is no element of such action which is left to be carried out, can there still be a subsequent declaration by this court as to the validity of such act having regard to the interpretation according to the provisions of the relevant statute. As discussed herein above, this court has acknowledged on several occasions that it has the competence to declare the law on a subject for posterity, even though no substantive relief may be given under the circumstances of a given case. Wide S.R. Bomai. The effect of such declaration would apply prospectively. That is, in the present case, if a declaration is made to the effect that the impugned action was unlawful, such declaration would only have the effect of deterring future measures from being carried out in a like manner in order to save such measures from the vice of unlawfulness. Such declarations as to validity or invalidity of a measure may be made by this court in exercise of its power under Article 141 of the Constitution, and the effect of such declaration may be molded or restricted by exercising the power vested with this court under Article 142. Reference may also be had to the decision of this court in Jayantilal versus Reserve Bank of India AIR 1997 SC 370. The said case pertains to the challenge of the constitutional validity of the High Denomination Bank Notes Demonetization Act 1978. Although the enactment related to the year 1978 and its effects were immediate, as in the present case, the validity of the same was conclusively declared by this court only in the year 1997. This court, while upholding the validity of the legislation impugned therein, authoritatively clarified and declared the law on the parliamentary power to enact such a legislation. A declaration of a similar nature, that is, as to the validity or invalidity of the impugned actions and notification, is what is sought for in the present petitions. In view of the aforesaid discussion, the following conclusions are arrived at. According to subsection 1 of section 26 of the Act, every bank note shall be legal tender at any place in India in payment or on account for the amount expressed therein and shall be guaranteed by the central government. This provision is subject to subsection 2 of section 26 of the Act. Subsection 2 of section 26 of the Act applies only when a proposal for demonetization is initiated by the Central Board of the Bank by way of a recommendation being made to the central government. The said recommendation can be in respect of any series of bank notes of any denomination which is interpreted to mean any specified series of bank notes of any specified denomination. Stop.